Isn't it surprising that about 9 out of every 10 court cases in the U.S. happen at the state level?
It really is.
You'd think with all the attention on federal courts, the numbers would be, I don't know, different. So that leaves us with the other 10%. What goes on there, and how does the whole American legal system actually fit together?
That's the fascinating puzzle we're tackling in this deep dive. We're going to explore the structure of the American judicial system and, maybe more importantly, how it functions as a guardian of both our Constitution and, the individual rights it guarantees.
Exactly. We've got a great source here that lays out the U.S. court system, looking at its history, the way it's set up with federal and state levels, and its really crucial role in our society.
Yeah, our goal today is to really understand how these courts operate within this dual system you've got, federal and state, as these protectors. We'll be focusing quite a bit on why the federal courts are so significant, and of course, we'll be diving into the role of the Supreme Court. Okay, let's get into it. It's kind of wild to think that when the country was first starting under the Articles of Confederation, there wasn't even a national court system.
No national judiciary at all. A big weakness.
Then the Constitution comes along, and Article 3 creates the judicial branch. But here's a curious detail. Article 3 is the shortest and, well, least detailed of the articles setting up the main branches. It basically just says there will be one Supreme Court.
Right, and it vaguely sketches out what it can do, leaving Congress to figure out a lot of the specifics. I mean, a lot.
Yeah.
And it's crucial to note that the initial vision for the Supreme Court really focused primarily on its role as a reviewer and appeals court.
Okay.
The Constitution outlines its original jurisdiction, those specific types of cases it hears first, like, say, disputes between states or involving foreign diplomats. Pretty limited, actually.
So mostly hearing cases after lower courts. Exactly. Its main job, as initially conceived, was appellate jurisdiction hearing cases that have already gone through those lower courts.
Right.
This design really emphasizes its function as sort of an overseer of the legal system.
Right. And Alexander Hamilton, in Federalist Number 78, he thought of the courts as a safeguard against unfair loss, which sounds pretty important.
It does.
But then he called it the least dangerous branch because it has, quote, merely judgment and lacks the force nor will of the other branches. It's like he saw them as this quiet umpire.
Well, consider this. Hamilton's view reflected those early anxieties about a strong central government, right?
Uh-huh.
The judiciary, lacking the executive's power to enforce decisions or the legislature's control over money, it just seemed inherently weaker. But, the subsequent development of judicial review and the court's growing influence on policy have definitely challenged that initial assessment. Big time.
Absolutely. Because then Congress steps in with the Judiciary Act of 1789, which is really the foundation of the federal court system we have today.
That's the one.
It established the basic 3 levels: district courts for trials, circuit courts for appeals, and the Supreme Court sitting at the top.
Yeah, that act took the basic framework laid out in Article 3 and gave it, well, a concrete form. It created the lower federal courts that Article 3 only hinted at. And this 3-tiered structure is mirrored, as we'll see, at the state level, too.
But even with this structure in place, the early Supreme Court really struggled, didn't it, to gain traction? Can you imagine the highest court having trouble just getting enough justices to show up for work?
It sounds incredible now, but yeah.
And no permanent home, just sharing a room with Congress that apparently wasn't very dignified. It wasn't until 1935 that they finally got their own building, with those powerful words carved on it: equal justice under law and justice the guardian of liberty. That building really seems to symbolize their eventual authority.
It really does. The journey from those uncertain beginnings to the iconic Supreme Court building truly reflects the gradual strengthening of the judiciary's role and its perceived significance within the American government. The mottos themselves, they articulate the fundamental principles the court aims to uphold.
And they faced early pushback, too. Remember Chisholm v. Georgia?
Oh, yeah?
Where the court said that citizens of one state could sue another state in federal court? That decision was almost immediately overturned by the 11th Amendment.
Right away.
Showing that Congress could definitely limit the court's power by changing what kinds of cases they could hear, their jurisdiction.
And this raises an important question about the balance of power, doesn't it? The swift reaction to Chisholm highlights the ongoing negotiation and maybe tension between the branches regarding the limits of federal judicial authority and the protection of state sovereignty.
Then comes Chief Justice John Marshall. He's often credited with really shaping the modern court.
A pivotal figure, absolutely.
And one of the biggest things he did was establish judicial review in Marbury v. Marison in 1803. Now, judicial review this power of the courts to say that actions of the other branches, federal and state, are unconstitutional isn't even explicitly written in the Constitution.
No, it's not.
The court basically declared that power for itself.
It's fascinating how Marshall strategically asserted this authority. While not explicitly stated, the rationale behind judicial review, ensuring the Constitution remains, the supreme law of the land became a cornerstone of the judiciary's function as a check on the other branches.
Okay.
It essentially positioned the courts as the ultimate interpreters of the Constitution's meaning and its limitations. The key takeaway here is that a power not explicitly granted was, seized, and it became the bedrock of the court's authority.
And it didn't stop with just federal actions. Judicial review expanded to include state and local levels.
That's right.
And it's used by all levels of both federal and state courts. So any law, any action by the executive branch at any level of government could potentially be struck down if it's found to violate the Constitution. That's a tremendous power.
And if we connect this to the bigger picture, the expansion of judicial review has profoundly shaped the relationship between the federal government and the states, as well as, the distribution of power within each level of government. It's an ongoing process of interpretation and defining boundaries.
Now, it's not just about saying no. The courts also play a significant role in shaping public policy.
Right.
We operate under a common law system in the U.S., which is essentially law created by judges through their rulings.
A Hodgmate law.
Unlike code law systems, where laws are very detailed and judges mostly just apply them, our judges interpret the law, and their interpretations have a real-world impact.
And what's fascinating here is the interplay between the legislative and judicial branches. Congress and the president often deal with broad policy issues, right? While the courts address specific cases, this allows the judiciary to refine and shape policy through its rulings on the particular facts presented in each case.
Think about the Affordable Care Act. There were all these legal challenges: National Federation of Independent Business v. Sebelius, Burwell v. Hobby Lobby, King v. Burwell.
Whole series of them.
And the Supreme Court essentially acted as this umpire, defining and clarifying the law through its decisions. Essentially, the court didn't just rule on legality. It's significantly reshaped how this major piece of legislation operates.
Those ACA cases perfectly illustrate the court's role as both an interpreter and a shaper of policy. Congress passed the law, sure, but it was the Supreme Court's rulings that determined the scope and application of key provisions, impacting millions of lives.
And it's not just about specific laws. The courts are constantly interpreting the Constitution and applying its principles to modern situations.
All the time.
Take, for example, that case about rap lyrics on Facebook not being considered a true threat. The people who wrote the First Amendment could never have imagined Facebook.
Not in a million years.
But the courts have to figure out how freedom of speech applies in the digital age. It's often said that the Constitution evolves more through interpretation than through formal amendments.
That's a crucial point. The Constitution is a relatively concise document, right? And its lasting relevance comes from the court's ability to adapt its principles to new technologies and evolving societal norms. This process of interpretation is continuous and reflects the dynamic nature of our constitutional framework.
And for individuals who believe they've been wronged, the courts are often seen as a last resort.
The place to turn.
Our legal system is adversarial, meaning one party argues against another before an impartial judge or jury who makes the decision. And the federal courts are often where you go if you believe your fundamental rights under the Constitution have been violated.
The adversarial system, with its roots in common law, it really places the responsibility on the parties involved to present their case. The courts then act as a neutral forum to resolve these disputes, particularly when fundamental rights are at stake.
Remember the Abercrombie and Fitch case?
Yes, the headscarf case.
Samantha Iloff, a Muslim woman who wore a headscarf for religious reasons, wasn't hired because of the company's dress code. The Supreme Court ruled that her First Amendment rights were violated and that she could sue for religious discrimination.
Exactly.
That really shows how the courts protect individual religious freedom in the workplace.
That case is a powerful example of how the courts can translate broad constitutional principles like freedom of religion into concrete protections for individuals facing discrimination in their daily lives. It highlights the practical impact of judicial rulings on individual liberties.
And we've seen so many significant Supreme Court cases that have expanded individual rights, like Brown v. Board ending segregation,
The landmark case.
Gideon v. Wainwright guaranteeing the right to an attorney, Miranda v. Arizona requiring the reading of rights, and all the way to Obergefell v. Hodges for same-sex marriage. It's a long list of instances where the courts have stepped in to broaden freedoms.
What's fascinating here is the breadth of rights the Supreme Court has addressed over time. These cases reflect evolving societal values and the court's willingness to reinterpret constitutional principles in light of these changes, often leading to significant shifts in American society.
But the courts rarely grant unlimited rights, do they?
No, that's true.
They have to find a balance between individual freedoms and the government's need to govern and, provide for the common good.
Right.
Look at the death penalty. The court has upheld its constitutionality, but has also set limits on who can be executed, for example, not people with significant cognitive disabilities or minors or those convicted of non-homicidal child rape.
This balancing act is crucial. The courts recognize that rights are not absolute and must be considered within the context of public safety and the government's responsibility to maintain order. These limitations on the death penalty illustrate this careful consideration.
And the interpretation is always ongoing. Even with something like lethal injection, there have been legal challenges like the Glossop v. Gross case in Oklahoma, where inmates argued it was cruel and unusual punishment. The court rejected that claim, and they also rejected a similar claim in Buckle v. Forsyth in 2019.
That's right.
It's interesting that even with these rulings, the actual number of executions has decreased. It feels like the legal questions around this are far from being completely settled.
This highlights the dynamic nature of constitutional law. Even when the court issues a ruling, dissenting opinions and changing circumstances can lead to future challenges and reinterpretations. The declining number of executions, despite these rulings, could reflect maybe shifting societal attitudes or practical difficulties in implementing the death penalty.
So when you look at the evolution of the judicial branch, from those uncertain beginnings to its current role, it's clear that it has become a truly significant player, gaining authority and trust to become this separate and co-equal branch of our government.
Absolutely. The evolution of the judiciary underscores the adaptability of the American system and the ongoing effort to define and protect individual rights within a framework of laws and constitutional principles.
Now, let's switch gears and talk about something equally fundamental. The dual court system.
Okay.
We have federal courts, but we also have state courts, and both generally follow this three-tiered structure of trial courts, appellate courts, and then a Supreme Court.
Right, that basic hierarchy.
This system has roots going all the way back to before the Constitution, when the colonies had their own legal systems based on English common law.
And it's crucial to note the deliberate choice to maintain this dual structure. It reflects the principles of federalism, dividing judicial power between the national and state governments. Figure 13.4 provides a good visual.
Yeah, I see it here.
With the U.S. Supreme Court at the top, hearing appeals from both the federal circuit courts and state Supreme Courts. Below that, you see the U.S. district courts at the federal trial level and the parallel structure at the state level. State trial courts, intermediate appellate courts, and state Supreme Courts. The tension inherent in this dual court system is really the trade-off between, say, localized justice and the potential for inconsistent application of fundamental rights across the nation.
And it can get a little complex because these systems can interact and sometimes overlap.
Definitely.
Plus, each state established its own court system, so there are variations in how they're structured, the number of courts, even their names and what kinds of cases they can hear. It's not a perfect mirror of the federal system.
Exactly. While the general three-tiered model is common, the specific organization and jurisdiction can vary significantly from state to state. This reflects the idea that states retain considerable autonomy in establishing their own judicial processes.
So how might, say, a contract dispute be handled differently in California versus Texas?
Well, the specific state laws governing contracts might differ. The procedures in the state courts could vary. Even the way judges are elected versus appointed can influence things. It speaks to that localized justice idea, but also potential inconsistency.
So how do cases actually make their way to the U.S. Supreme Court? It sounds like there are two main paths.
That's right.
Either up through the federal system, starting in a federal district court, then to a federal circuit court of appeals, or from a state Supreme Court, but only if there's a significant question involving federal law.
That's the key distinction. The Supreme Court primarily hears cases that raise substantial issues of federal law or the Constitution. Cases that start in state courts can only reach the Supreme Court after all state-level appeals have been exhausted, and only if they involve a federal question. Let's break down those pathways a bit.
Okay, now what kind of disputes do these different courts handle? We've got criminal law.
Right, government versus individuals.
Defining prohibited conduct and punishments. And then there's civil law, which is disputes between private parties who claim they've been harmed.
Private grievances, essentially.
And the U.S. Supreme Court is the final court of appeal in both.
That's a clear way to categorize the types of cases. Criminal law focuses on offenses against the public, while civil law addresses private grievances. The Supreme Court's role as the ultimate arbiter in both areas underscores its broad authority in the American legal system.
It's almost unbelievable to think about the sheer volume of cases. State courts handle about 90% of all legal cases in the U.S.
It's staggering, isn't it?
The federal caseload is relatively small in comparison.
That statistic really highlights the central role of state courts in the day-to-day administration of justice. They are the workhorses of the judicial system, handling the vast majority of legal disputes.
So if you're dealing with most crimes like robbery or assault or civil matters like personal injury or divorce,
Right.
you're probably in a state court.
Most likely, yes.
Federal courts, on the other hand, handle things like cases involving foreign governments, issues related to patents and copyrights, disputes between states, and cases where the U.S. government itself is a party. There's also that rule about diversity of citizenship. If the people involved in a civil lawsuit are from different states or countries, and the amount of money in dispute is over $75,000, it can go to federal court.
Those jurisdictional lines reflect the areas where the federal government has a particular interest or, constitutional responsibility. Cases involving interstate commerce or disagreements between states, for instance, fall under federal jurisdiction to ensure consistency and resolve conflicts between different state laws.
But there are cases that cross over, right?
Yes, definitely.
Any case that brings up the U.S. Constitution or a federal law could potentially end up in federal court, whether it starts as a criminal or civil matter. And even if it starts in state court, on a state issue, if it later raises a question about federal law, it can eventually make its way to the federal system after going through all the state appeals.
That's the interconnectedness of the dual system. While state courts primarily interpret state law, the supremacy clause of the Constitution means that federal law is the ultimate authority. So, any case involving a conflict between state and federal law or a question of federal constitutional rights can be appealed to the federal courts after all state avenues have been exhausted.
The Miranda v. Arizona case is a perfect example of this, isn't it?
Absolutely classic example.
Miranda was convicted in state court for kidnapping and rape, but the Supreme Court overturned his conviction because his Fifth Amendment right against self-incrimination and his Sixth Amendment right to an attorney were violated during questioning.
Yep, didn't read him his rights.
The whole Miranda rights precedent came out of a state-level case.
Yeah.
And even after the Supreme Court ruling, he was retried in state court on other evidence and convicted again.
Right.
It really shows how the state and federal systems operate together. State courts deal with whether someone broke state law, while federal courts address constitutional questions.
Miranda's case is a perfect illustration of how the dual system can provide multiple layers of protection for individual rights. While the state court initially found him guilty, the federal courts intervened to ensure his constitutional rights were upheld, establishing a nationwide precedent in the process.
So this dual system has benefits multiple ways to protect your rights, like in Miranda's case, but also potential downsides. There can be different legal standards and outcomes in different states.
Exactly. The benefit lies in having different forums to address legal issues and protect rights, potentially leading to more tailored justice depending on the specific state. However, the drawback is the possibility of inconsistencies and disparities in how the law is applied across the country.
And state courts themselves have a lot of variation. Research by Brace and Hall suggests they're really important for democracy, providing different places for people to engage with the legal system and potentially influence policy through the courts.
Yeah, one size does not fit all, as they put it. Their research highlights the idea that state courts can be more responsive to local political cultures and offer avenues for diverse groups and interests to seek legal remedies. This diversity can be seen as a strength of the federalist system.
But it also means you could potentially face legal consequences in different courts for the same underlying issue.
Sure.
State law governs state courts, except for the U.S. Constitution, which applies to all judges. So what's legal or illegal can vary quite a bit from state to state, like we see with marijuana laws.
This is a key point of tension within the dual system. The fact that state laws can differ significantly, even on the same subject, can create legal complexities and challenges, especially when those state laws conflict with federal law.
Marijuana laws are a perfect example of this conflict.
Prime example.
What's legal for recreational or medical use in one state is still illegal under federal law, which classifies it as a Schedule I drug.
So Schedule I federally, yeah.
This leads to these complicated situations where people can be arrested and face federal charges, even in states where it's legal, and the federal government can even raid businesses that are operating legally under state law. There have even been lawsuits arising from these clashes. Figure 13.5 really shows how different state marijuana laws were back in mid-2021.
The marijuana issue perfectly illustrates the challenges of a dual system when state and federal laws diverge so significantly. It creates legal uncertainty and raises fundamental questions about federal authority versus state autonomy.
And it's not just the laws themselves. The political culture and how judges are chosen at the state and local levels, whether they're elected or appointed,
That makes a difference too.
can also influence how they rule. This can lead to even more inconsistencies in how the law is applied across the country. Plus, you don't always get to choose which court hears your case. Where you are geographically matters.
The method of judicial selection and the prevailing political climate within a state can indeed impact judicial decision-making. For example, elected judges might be, well, arguably more sensitive to public opinion. These factors contribute to the variations we observe across state court systems.
So the dual system provides these different places to resolve legal issues, which can be helpful for protecting rights, but it can also lead to real differences in how people are treated depending on where they live.
Exactly. The dual court system is a direct outcome of our federalist structure, offering both opportunities for diverse legal approaches and the potential for inconsistencies in the application of law.
Now let's focus specifically on the federal court system. We know it has that clear three-tiered structure, district courts as the trial level,
The entry point.
then the circuit courts for appeals, and finally the Supreme Court at the top. And a really important principle here is that decisions made by higher courts must be followed by the lower courts.
That hierarchical structure is essential for ensuring consistency and coherence within the federal judiciary. It establishes a clear line of authority and a mechanism for correcting errors made at lower levels.
And the idea of precedent, or stare decisis, which basically means to stand by things decided, is super important.
Crucial.
Today's legal decisions are largely based on rulings from the past. This is vital for the system to be seen as legitimate, especially since federal judges aren't elected. It creates a sense of logic and consistency in the law. Think of stare decisis as the legal principle of, if it ain't broke, don't fix it. Courts generally stick to past decisions to ensure predictability.
Stare decisis provides stability and predictability to the legal system. By adhering to precedent, courts ensure that similar cases are treated similarly, fostering public trust in the impartiality and consistency of the judiciary.
So the district courts, there are 94 of them across the states and territories.
Right, 89 in the states themselves.
They are the trial courts for federal cases, with a single judge and sometimes juries, and no district court crosses state lines.
These are the workhorses of the federal trial system, where facts are established, evidence is presented, and initial rulings are made in federal legal disputes. The geographic boundaries ensure that each district court is rooted within a specific state or territory.
Then we have the courts of appeals, or circuit courts. There are 13 of them.
11 geographic, plus 2 in D.C.
They have rotating panels of 3 judges, and they review the decisions of the district courts. They don't hold new trials. There are currently 179 of these judges. They're the intermediate level of appeals courts. And because different circuits can sometimes have different interpretations of the law, the Supreme Court often has to step in to provide the final clarification. Figure 13.6 shows a map of these 13 circuits.
The circuit courts play a vital role in reviewing appeals from the district courts. And the fact that different circuits can interpret the law differently, that really highlights the potential for regional variations in federal law and underscores the Supreme Court's function in ensuring national uniformity, resolving those circuit splits.
It's interesting to look back at how the federal courts developed. Congress established the district courts fairly early on with a limited scope of what they could hear, mostly cases that happened within that specific district.
Initially quite limited, yeah.
But over time, their authority expanded, particularly to include cases involving federal law. And then the Judicial Code of 1911 essentially made the district courts the main trial courts for most federal cases.
The evolution of the district courts reflects the growing scope of federal law and the increasing role of the federal judiciary in addressing constitutional and statutory matters. The 1911 Code marked a significant consolidation of their authority at the trial level.
The circuit courts also went through a transformation. They started out as trial courts for federal criminal cases and some civil lawsuits.
Right, but they didn't even have their own dedicated judges at first.
No, it was the local district judge and two Supreme Court justices who would travel around to hear cases that practice called writing circuit.
Can you imagine the burden on the Supreme Court justices?
Seriously. Eventually, in 1891, their power to hear appeals from district court civil cases was ended and given to the newly created Circuit Courts of Appeals. The original circuit courts were finally done away with in 1911. Sounds like a bit of a messy evolution.
It was. But the history of the circuit courts illustrates the challenges of establishing an efficient and effective appellate system. That early practice of writing circuit highlights the initial burdens on the highest court and the gradual development of a dedicated appellate judiciary. It eventually led to the more stable system we have today, which is crucial for the consistent application of federal law across different regions.
We also have specialized federal trial courts, like the Court of International Trade and the Tax Court,
Handling specific types of cases.
and then specialized federal appeals courts for areas like the armed forces and veterans' claims. Appeals from these to the Supreme Court are quite rare, I gather.
They are. These specialized courts address specific and complex areas of federal law, allowing for expertise and efficiency. For example, the Court of International Trade might handle a dispute between a U.S. company and, say, the government over tariffs on imported steel. While their cases can theoretically reach the Supreme Court, the vast majority are resolved within these specialized systems.
And then there's the Supreme Court. 9 justices, 1 chief justice, and 8 associate justices.
Top of the pyramid.
They are the final court of appeal in the country, and they set the standards for how all lower courts should interpret the law. Their decisions are binding nationwide and establish the precedents that all 3 levels of federal courts must follow.
The Supreme Court sits at the apex, not only resolving specific legal disputes, but also shaping the interpretation of the Constitution and federal law for the entire nation. Its decisions have a profound and lasting impact on American society.
Let's go back to stare decisis for a moment. It means relying on past court rulings to ensure consistency, predictability, and stability in the law.
Right. Stand by things decided.
Justice Cardozo had that great quote about how following precedent has to be the norm so that people have faith in the fair administration of justice.
Justice Cardozo's quote really gets to the core of why stare decisis is so important. It fosters predictability and public confidence in the legal system by ensuring that legal principles are applied consistently over time.
But it's not set in stone, is it? New precedents can be established as times change and the composition of the court evolves.
Absolutely not set in stone.
Think about the shift from the separate but equal doctrine in Plessy v. Ferguson to the ruling against segregation in Brown v. Board of Education. That was with a completely different set of justices on the Supreme Court.
That's a critical point. While stare decisis promotes stability, it doesn't mean the law is unchangeable. The court retains the ability to overturn its own past precedents when it determines they are no longer sound or consistent with evolving understandings of the Constitution. Brown v. Board is a powerful example of this.
Now, how do these federal judges get their jobs? The president nominates them, and the Senate has to confirm them with a majority vote. That's the advice and consent rule. And they serve for the rest of their lives. Lifetime tenure.
The appointment process reflects the separation of powers, with both the executive and legislative branches playing a role in selecting federal judges. And that lifetime tenure is intended to provide judges with independence from political pressures.
The president might look at recommendations from the American Bar Association, then the Senate Judiciary Committee holds hearings and votes, and finally the full Senate votes.
That's the whole process.
And there's this practice called senatorial courtesy for lower court openings.
Right, less so for Supreme Court.
Where the president often consults with the senators from the nominee's home state, especially if those senators are from the same political party. This seems to give senators a lot of influence, maybe even the power to block a nominee.
It can. Senatorial courtesy is an interesting example of informal political influence in the judicial appointment process. It allows senators to protect their state's interests and preferences, potentially leading to, well, maybe less contentious, but perhaps also less independent nominees sometimes.
Supreme Court appointments get a huge amount of public attention these days, don't they? Especially with the internet and social media.
Oh, absolutely. Intense scrutiny.
We saw that with Obama's picks like Sotomayor and Kagan, and Trump's like Gorsuch, Kavanaugh, and Barrett. Figure 13.7 shows these justices and who nominated them, along with their general ideological leanings.
The increased public scrutiny of Supreme Court nominations reflects the high stakes involved, given the court's significant influence on national policy and constitutional interpretation. The ideological alignment of nominees with the president is often a key consideration.
And because they serve for life, these appointments can be a really long-lasting legacy for a president.
Decades, potentially.
Obama got his generally liberal choices confirmed when the Democrats controlled the Senate, and Trump got his generally conservative choices through when the Republicans controlled it.
The lifetime tenure of Supreme Court justices means that their impact can extend for decades, shaping legal precedent and influencing the direction of the country long after the president who nominated them has left office.
But it's not always predictable. Justices don't always vote the way the president who nominated them might have expected.
No, they don't. There are famous examples.
Eisenhower apparently later regretted picking Earl Warren.
Right.
Reagan's appointee O'Connor was a big advocate for women's rights. G.H.W. Bush's pick Souter often sided with liberals. And even conservative justices like Roberts have sometimes surprised people, like with the Affordable Care Act rulings.
These examples highlight the independence that lifetime tenure is meant to foster. Once confirmed, justices are free to interpret the law according to their own judicial philosophies, which may not always align perfectly with the expectations of the president who nominated them.
The idea behind lifetime tenure is to protect them from political pressure. But the Kavanaugh confirmation process felt incredibly partisan, really putting that idea to the test.
It really did.
Chief Justice Roberts even expressed his concern about the level of partisanship surrounding the courts.
The Kavanaugh confirmation underscored the increasingly politicized nature of judicial appointments, particularly to the Supreme Court. Chief Justice Roberts' concern reflects the potential for this partisanship to undermine the public's perception of the court as an impartial institution.
And we've seen some pretty controversial and even unsuccessful Supreme Court nominations over the years, like Robert Bork, Douglas Ginsburg, Harriet Miers. Figure 13.8 shows some of these. Then there was Alito getting confirmed after Miers withdrew.
These failed nominations illustrate the intense scrutiny that Supreme Court nominees face, and the various factors: ideological opposition, questions about qualifications, even personal conduct that can derail a nomination.
One positive trend, though, is the growing diversity of the federal courts over time. Table 13.3 shows some of the firsts on the Supreme Court.
Yeah, it's interesting.
First Catholic justice, first Jewish justice, first African American, first woman, first Hispanic American. The lower courts are also becoming more diverse, although they still don't fully reflect the diversity of the country compared to white men.
Right. The statistics from 2021 showed progress, but still a way to go. About 67% men, 74% white on the federal bench overall back then.
So progress, but more needed.
The increasing diversity of the federal judiciary is definitely a positive development, reflecting the changing demographics of the nation. But, yes, the continued underrepresentation of women and minorities highlights the ongoing need for efforts to promote a more inclusive judiciary.
Finally, let's really dig into the Supreme Court itself. It's often called a one-of-a-kind institution at the very top of the judicial branch.
It's really unique.
And while we often focus on the 9 justices, there's a whole team of administrators, lawyers, and assistants who support their work.
It's a whole operation. The Supreme Court is indeed a unique institution, not just because of its position at the apex of the judicial system, but also because of its specific procedures and the profound impact of its decisions on American law and society.
It's been set at 9 justices since 1869, 1 Chief Justice, and 8 Associate Justices.
That number's held for a long time.
All serving lifetime terms after being nominated by the president and confirmed by the Senate. There have been discussions about increasing the number of justices in the past, FDR's court packing plan being the most famous, but it's never actually happened.
The size of the Supreme Court has been a subject of political debate throughout history, but the number 9 has remained constant for over a century. Discussions about court expansion often arise during periods of significant political division.
The current court, as of June 2021, figures 13.9 and 13.9 show the justices then, is quite diverse in terms of gender, religion, ethnicity, ideology, and how long they've served. There's a mix of justices who are generally considered conservative and those considered liberal, currently 6-3 conservative, but the justices don't always vote in a way that perfectly aligns with those labels. They consider each case individually.
Right. While ideological leanings can often provide a general indication of a justice's likely approach to certain issues, the complexity of legal cases and the justice's commitment to interpreting the law mean that their votes are not always strictly along partisan lines.
And they don't make these decisions in a vacuum. Each justice has 3 or 4 law clerks,
Crucial support staff.
usually recent top law school graduates who do a huge amount of work researching legal issues, providing background information on cases, and even helping to draft opinions. They can even have some influence on which cases the justices decide to hear. It sounds like they play a really important role behind the scenes.
Law clerks play an absolutely crucial role in supporting the justice's work. Their research and analysis contribute significantly to the justice's understanding of the cases and the development of their opinions. The insider perspective profile really highlights the breadth of their responsibilities, reviewing cases, prepping for arguments, research, drafting, emergencies. It's a lot.
When it comes to choosing which cases to hear, the Supreme Court starts its annual session in October and goes until late June or early July.
First Monday in October.
Thousands of people and organizations want their cases heard by the Supreme Court, sending in these petitions, but they actually accept less than 2% of them for their docket, their schedule of cases.
Tiny fraction. The Supreme Court's limited capacity necessitates a very selective process. The vast majority of appeals are denied, highlighting the court's focus on cases of significant national importance or where there is a clear disagreement among the lower courts.
Case names are always written as petitioner v. respondent, with both names in italics. The petitioner is the party who lost in the lower court and is the one asking the Supreme Court to hear the case.
Right, the one bringing the appeal.
And usually they're filing a request for a writ of certiorari, often just called cert,
Asking the court to take the case.
which in order for the lower court to send up the records of the case for the Supreme Court to review. It takes at least 4 of the 9 justices to agree to grant cert that's known as the Rule of 4.
The Rule of 4 ensures that at least a significant minority of the justices believe a case warrants the court's attention. The certiorari process is the primary way cases reach the Supreme Court, allowing the justices to exercise their discretion in shaping their agenda.
There are specific reasons why the court is more likely to grant cert, like if different lower courts, different circuit courts, usually have ruled differently on the same legal issue.
Creating a circuit split.
Or if a lower court decision goes against a previous Supreme Court ruling, or if a state court ruling conflicts with federal law. Sometimes they even expedite the process for really urgent cases, like Bush v. Gore.
These criteria, often referred to as Rule 10, guide the court's decision-making in granting certiorari, prioritizing cases that involve significant legal questions, conflicting interpretations of the law, or matters of national importance. Resolving those conflicts is a key job.
Interest groups definitely try to influence which cases the court agrees to hear, though maybe their direct impact on cert decisions is debated.
Yeah, research differs on that.
But other outside factors certainly play a role, like how much public and media attention a case is getting, and especially the involvement of the Solicitor General.
The Solicitor General, the SG, represents the federal government before the Supreme Court. They have a unique level of influence due to the government's frequent involvement in cases concerning federal law.
Right. The Solicitor General decides which cases involving the U.S. government get appealed and has to approve every single one. They have a really high success rate of getting cert. Granted, about 2/3 of all Supreme Court cases involve the federal government in some way. Figure 13.11 shows Thurgood Marshall, a former SG, and Noel Francisco, who was SG more recently.
They basically decide the government's legal argument, file written briefs, and present oral arguments in court. They can even submit briefs in cases where the U.S. isn't directly involved as an amicus curiae or friend of the court.
Friend of the court.
Sometimes, before granting cert, the justices will even ask the Solicitor General for their opinion on a case, which shows how much they value their input.
They're sometimes called the 10th Justice because of how much influence they have.
The Solicitor General's role is indeed pivotal. Their expertise and the federal government's significant stake in many legal issues give them considerable access and influence before the Supreme Court, shaping the court's agenda and the arguments it considers. Obama's S.G. Verrilli arguing for same-sex marriage in Obergefell is a good example.
So once the Supreme Court agrees to hear a case, both sides submit their written arguments called briefs.
Laying out their case.
Then other interested parties who aren't directly involved in the case can also submit amicus curiae briefs offering their perspectives.
Interest groups, academics, other governments sometimes.
After that, there are oral arguments, which usually take place between October and April. It's a pretty formal proceeding, isn't it?
Hmm.
With the justices in their robes, the banging of the gavel, and the marshal's traditional announcement.
Very traditional. Oyez, oyez, oyez.
Each side's lawyers get 30 minutes to present their case, but the justices often interrupt with questions. They're not there to just listen to a speech.
Not at all. The oral argument phase provides the justices with a crucial opportunity to directly engage with the lawyers, to probe their arguments, clarify points, and explore the nuances and potential consequences of a ruling. It's a dynamic and often intense exchange.
After the oral arguments, the justices meet in private conferences to discuss the cases and also the petitions for certiorari that are still pending.
Twice a week, usually, when they're hearing arguments.
The Chief Justice speaks first, and then the other justices speak in order of seniority. They take an initial private vote on the case. Finally, they announce their decisions publicly.
Right.
And one tradition that's still in place is that cameras aren't allowed in the courtroom. We only see artists' sketches. There's always a debate about whether this promotes the solemnity of the proceedings or hinders transparency.
It's an ongoing debate. The court's procedures, while rooted in tradition, are designed to ensure a thorough and deliberative process. The absence of cameras reflects a concern for maintaining this solemnity and preventing maybe grandstanding or undue influence from public or media pressure.
Now, when we think about how the Supreme Court actually makes its decisions, it's interesting that it's probably the least visible and least understood branch of government in terms of its day-to-day operations.
Yeah, much less public than Congress or the White House.
Most of their written opinions just get quietly published in the United States reports. The ruling on same-sex marriage, Obergefell, was a notable exception in terms of public attention.
That's true. While the outcomes of major Supreme Court cases often generate significant public discussion, the detailed reasoning behind those decisions and the court's internal processes tend to receive less widespread attention.
But the justices aren't totally isolated. They are influenced by things happening outside the court. They don't have their own way to enforce their rulings, and their power is checked by the other branches of government.
Right, that enforcement piece is key.
But their decisions have a massive impact on our government, our politics, and our society.
Despite lacking direct enforcement power, the Supreme Court's authority ultimately rests on the legitimacy of its interpretations and the willingness of the other branches and the public to respect its rulings. Its impact on American life is undeniable.
Every Supreme Court opinion sets a precedent. There's the majority opinion, which is what more than half of the justices agree on.
The official ruling of the court.
Then there can be dissenting opinions from the justices who disagree with the majority.
Explaining why they disagree.
And concurring opinions from justices who agree with the final outcome, but for different legal reasons.
I agree with the result, but here's my thinking.
The Chief Justice, if they're on the winning side, or the most senior justice in the majority, gets to choose who writes the majority opinion. The most senior dissenting justice chooses who writes the main dissenting opinion. These decisions are released throughout their term, with the really big controversial ones often coming out near the end in June.
The different types of opinions allow the justices to express their individual views and the reasoning behind their decisions. Majority opinions establish binding precedent, while dissenting and concurring opinions can influence future legal arguments and potential shifts in the court's jurisprudence. They can be seeds for future changes.
We've talked about how law clerks and the Solicitor General can influence the court, but interest groups and the media also play a role, especially when it comes to which cases get heard.
External factors.
And then there are the more internal or personal factors.
Mm-hmm.
The specific facts of the case, the Constitution itself, existing laws, previous court rulings, but also the justices' own personal beliefs, their general ideological leanings, their political views, and even, to some extent, public opinion.
The decision-making process at the Supreme Court is a complex mix of legal principles, individual philosophies, and external influences. While justices strive for objectivity, their personal backgrounds and beliefs inevitably play some role in how they interpret the law.
There are these two main approaches, or maybe philosophies, to thinking about the role of the courts. Judicial activism,
Mhm.
which is about actively defending individual rights and striking down laws that violate them, often with a broader interpretation of those rights, and judicial restraint, which is more about deferring to the decisions of the elected branches of government and interpreting the Bill of Rights more narrowly.
Right. Restraint usually means upholding laws unless they're clearly unconstitutional.
People who disagree with a court's decision often accuse it of activism. As Justice Kennedy famously said, an activist court is a court that makes a decision you don't like.
Yeah, that quote sums it up pretty well. These contrasting judicial philosophies reflect different views on the proper role of the courts in American government. Activism suggests a more assertive role in protecting rights and correcting injustices, while restraint emphasizes deference to the democratic process.
It seems like, generally speaking, judges considered liberal might lean towards more liberal outcomes, and judges considered conservative might lean conservative, although it's definitely not always that simple, as we saw earlier.
No, not always predictable.
Presidents definitely try to nominate people who share their own general political and legal views, but finding someone who's completely free of any political leaning is probably impossible.
The ideological leanings of judicial nominees are a significant factor in the appointment process, as presidents aim to shape the direction of the court for years to come. However, as we've discussed, justices don't always adhere strictly to the expected ideological path once they're on the bench.
And then there's public opinion. Even though they are somewhat insulated from direct political pressure because of their lifetime appointments, justices might still be influenced by special interest groups, government officials, the media, and the general public in order to maintain the court's relevance as society changes.
The Supreme Court, while not directly accountable to the electorate, operates within a broader societal context. Shifts in public opinion and evolving social norms can indirectly influence the court's interpretations of the Constitution over time. It doesn't operate in a total vacuum.
Think about laws against sodomy. They were upheld by the Supreme Court in 1986 in Bowers v. Hardwick. But then that decision was reversed in 2003 in Lawrence v. Texas, which invalidated all such laws across the country. That shift likely reflected the significant changes in state laws regarding same-sex relationships and the growing LGBTQ rights movement.
The Lawrence v. Texas decision is a clear example of how the Supreme Court's rulings can evolve in response to changing social attitudes and legal developments at the state level. It demonstrates the court's capacity to revisit and overturn its own precedents.
And even though we have appointed judges at the federal level, serving on a jury is a way for regular citizens like you to participate in the court system at both the state and federal levels.
A crucial part of the system.
It gives individuals a chance to have their voices heard and to ensure a fair trial by a group of their peers, and it can also be a really educational experience for the people who serve. Even former President George W. Bush was called for jury duty once.
Jury duty is a fundamental aspect of the American justice system, providing a mechanism for citizen participation and ensuring that legal decisions are informed by community values. It reinforces the idea of justice being administered, at least in part, by the people.
Finally, let's talk about how the courts interact with the other two branches of government. The executive branch has a check on the judiciary through the president's power to nominate judges, which has a lasting impact.
Huge impact.
And through the influence of the Solicitor General and the filing of amicus briefs. We even saw President Roosevelt's attempt to pack the court, which ultimately didn't succeed, but the threat was there.
The executive branch wields significant influence over the judiciary through the appointment process, which allows presidents to shape the ideological composition of the courts for decades. The Solicitor General also acts as a key link between the executive and judicial branches.
The legislative branch also has ways to check the courts. They can change the structure and authority, the jurisdiction of the federal courts.
Big power there.
The Senate has to approve judicial nominees. Congress can pass new laws to try to address issues raised by court rulings, and they can even start the process of amending the Constitution.
Congress's power to structure the federal court system, control its jurisdiction, and respond to judicial rulings through legislation or constitutional amendments provides essential checks and balances on the judiciary's authority.
But perhaps the most significant check is the power of the executive and legislative branches over implementing and enforcing court decisions. This is often called judicial implementation.
Yeah, the courts can't enforce their own rulings.
The courts don't have their own police force to make sure their rulings are followed. Remember Hamilton's point that they have merely judgment?
Exactly.
There's the famous example of President Andrew Jackson reportedly ignoring a Supreme Court ruling about Native American lands.
John Marshall has made his decision. Now let him enforce it. Or so the story goes.
And President Lincoln famously disregarding a court order regarding habeas corpus during the Civil War. Ultimately, the impact of court rulings depends on whether they are heeded and followed by the other branches.
The judiciary's reliance on the executive and legislative branches for the implementation and enforcement of its decisions highlights its dependence on the cooperation of the other branches. This is a crucial aspect of the checks and balances within the American system.
But generally, the other branches do provide support for court rulings. Think about when President Eisenhower sent federal troops to enforce the desegregation ruling in Little Rock after Brown v. Board.
Executive Order 10730. Yeah.
That really shows how the executive branch can step in to uphold court orders, even using force.
President Eisenhower's actions in Little Rock underscore the executive branch's responsibility to ensure that the Supreme Court's rulings are given effect, even in the face of significant resistance. It's a powerful example of the government acting to uphold the rule of law.
So in the end, the impact of court decisions depends on their credibility, whether they are practical to implement, and the support they receive from the other branches. It's also a matter of tradition and legitimacy.
Right. Generally, court rulings are accepted and followed, and the Supreme Court is respected as the key interpreter of our laws and the Constitution. Over time, their rulings have become a fundamental way that policy is made and justice is served in our country.
So, to recap this deep dive, the judicial branch has come a long way, hasn't it? Evolving into a vital part of our government that interprets the Constitution and protects our individual rights within this complex dual court system.
Definitely. The federal courts, and especially the Supreme Court, have a lot of influence through judicial review and the power of precedent, but their authority is also balanced by the other branches of government. Checks and balances at work.
And understanding this framework is crucial for you, the listener, to see how individual legal cases and their interpretation by the courts directly shape the society we live in, influencing everything from access to health care to the protection of our fundamental civil rights.
It really does touch almost every aspect of life.
Now, for a final thought to really make you think. Considering the ongoing debates about the role of the courts and how the Constitution should be interpreted in our modern 21st century world, what do you think is the single most critical challenge facing the American judicial system today as it tries to balance the protection of individual freedoms with the need to serve the common good?
That's a really important question for you to consider. To explore these complex issues further, we encourage you to check out the suggested books and films that offer deeper insights into specific Supreme Court cases, the lives of the justices who have shaped the court, and the intricate inner workings of the American judicial system.